The last benefit is to reduce the possibility of a court challenge. What was I just talking about? When analyzing a will or a trust, it's important to understand that a living trust is often more difficult to challenge in court than a will. Why? Because it's harder to prove incompetence. And let me explain. In order to successfully, discredit or undermine a trust, the individual who's raising that challenge has to prove that that documentation is invalid in some way, or that you, as the person, signing this document, were improperly influenced by a third party. What did I just talk about? A trust is actively managed by you during your life. It's not a single instance situation like, signing a last will and testament. So if you were able to facilitate the transfer and the management of assets during your lifetime, then it's a lot tougher to substantiate, a claim that you were somehow incompetent during this period. So unless you have a reason to suspect that family members are just going to be unhappy with your decision, an attack on a trust is unlikely. I didn't say impossible, I said unlikely. So what are some flags? What are some things that you should be aware of that could, like I said, be red flags and give you a hint that somebody's going to raise a challenge? What are the warning signs? Let's say that you don't want to leave property to your closest relatives. Okay, that's certainly going to raise some eyebrows. Let's say you're in a relationship that your relatives do not approve of. Or let's say you remarried and you have children that dislike the new spouse. Okay, those are all kind of red flags, things that you should be aware of that could be causes for a challenge at some point later on. So just keep those in mind.